Having a great Friday. Welcome to the next version of our webinar, wherein we will discuss on the components of salary and deep dive on the wage code, as well as the code on social securities. We have about 450 odd attendees, and the number is going up every second. So I would beg your indulgence for the next couple of half a minute while we have as many people. We've had. Is my voice audible to everyone? Because
Yes.
Yes. Okay.
Okay, some of the panelists, some of the audience is saying that my voice was not audible. There is a 5 second, there is a couple of seconds delay, so you might be hearing it. So we are at 550 attendees. We have about 1700 registrations, so we'll give them another 30 seconds to join in. So I would beg your indulgence to please wait for another 30 seconds while we welcome other folks. I think we are good to go now. We have about 670 odd attendees. I would like to extend once again. I would like to extend a warm welcome to all the attendees who've taken out time on a weekend to join this webinar. I would also like to welcome our experts, come panelists on this webinar. They are the important ones. Uh, we have two experts today. First is Sandeep. A lot of you will know Sandeep. He's the director and founder of TeamLease Regtech. He spent his formative years with PwC, where he developed his grounding in managing process, detail orientation, and how to build profitable businesses. Over the last 8 years or so, he's led the growth of both the digital and services verticals at TeamLease, shaping them into integrated and profitable businesses. He has an MCOM degree, is a certified information security auditor, and above all, is a chartered accountant. The second panelist and the expert on the panel is Mr. Madhu Damodaran. He serves on the board of directors here at TeamLease Regtech. He's also the regional managing partner at a boutique law firm called as AM Legal. And he contributes to several national forums, including being on the National IR Committee at CII and the Executive Committee at Employee Federation of India. He's also the part of the Central Board of Trustees of EPFO. His earlier roles were with LabourNet, Ascent, and TeamLease. He's a lawyer. He's a practicing lawyer by qualification. With that, I would like to pass the ball to both Sandeep and Madhu to take the discussion forward. I hope all the participants take a lot of stuff away from this, and we see them again in the third iteration of this of the labor code series that we are conducting. Madhu, Sandeep, over to you.
Thank you, Uthya.
Thank
Good
you.
evening, everyone. Thanks for joining the session. It's been 15 days since the new labor codes have been notified. Right. With that, 4 codes have came into force. 28 old labor laws have actually repealed. And with new labor laws yet to be notified, there are a lot of discussions going on with respect to timelines and applicability. There are a lot of people around us who keeps talking about whether we should take in actions today. Should we adopt a strategy of wait and watch and see how other corporates are doing? Or let us see as and when the rules gets notified, we'll start working on that. A lot of questions are getting answered by sessions like this. A lot of industry forums have conducted sessions. Private consulting arms have conducted sessions. Some questions have been answered. I'm still sure we today, all of us has questions which remains unanswered. In next 45 minutes, we'll try to spend time on discussing key provisions on two labor codes, code on wages and code on social security. And then based on our understanding and feedback from a lot of colleagues in the fraternity, we have identified certain set of questions that we will try and discuss and answer to them with respect to certain key provisions of these two codes. Plus, we'll also spend time on implications of these codes, these two codes on the components of salary, limited components, PF, ESIC, gratuity, and we'll see more, and understand whether what will happen, what needs to be done, what has changed, and how will it impact the employers as well as how will it impact the employees, both ways. And I'm sure there still can be certain set of questions. So we are trying to answer a few questions for each of these components of salary linked to the code as well. So instead of spending more time, let me just switch on to the presentation. I would like to spend more time on Q&A. So as I mentioned, this is what we will talk more on: overview of code on wages, overview of code on social security, very briefly on key provisions. I am sure that you all must have gone to multiple sessions and these are getting discussed as a part of the slide. So I will not spend much time there. Then the impacts. So before the impacts, we'll talk about those 15, 20 questions that we have restricted ourselves to. Thought is that these are questions which all of us has and we'll try and answer them. And then broader impacts of codes on PF, Provident Fund, employee state insurance, gratuity liabilities, maternity benefits, employee compensation, bonus. So these are broader heads which we believe are part and parcel of these two codes. And then we'll briefly talk about the actions that a corporate VP, as per us, should take on an immediate basis so that they can stay compliant. Jumping on to the overview, very briefly, if you look at the code when it came in 2020, Code of Social Security, it had 9 acts as per section 164, which had to be repealed when the code notifies. But the notification on November 21st actually repealed 8 acts in PF, which all of us know, EPFO. The act is still not repealed, and the provisions of PF Act will continue to remain in force until Ministry of Labor and Employment issues a specific notification to repeal it. So which 8 acts? Very briefly: employee compensation, state insurance, employee exchange benefit, maternity benefit, payment of gratuity, Senior Workers Welfare Fund, BOCW, and Unorganized Worker Social Security Act. These are all repealed at this point of time. Similarly, on Code of Wages, we're talking about 4 acts: payment of wages, minimum wages, payment of bonus, and Equal Remuneration Act, which now is not in force, and the 2 codes are in force. We'll speak more on what happens, although the rules are not there, but the codes are already notified. We'll speak more on the Q&A session as well. Now, what are the important provisions on Code of Wages? Very briefly, coverage. This now applies to all employees in organized and unorganized sector, which indicates that it covers all workers, whether it is a regular worker, casual worker, or a contractual worker. All of them has been categorized under same definition of coverage. The central government has introduced a new term, national floor wage. That's a minimum wage that central government intend to define at a central level, and there is an expectation that state minimum wages should be aligned to that. When I say alignment expectations, in case the floor wage is higher than any state's minimum wage, the states have to increase their minimum wages. On the other hand, if the state minimum wages are higher than the floor wage, then they cannot reduce it. It's the simple expectation. Thought is, when deciding these floor wages, central government will ensure and keep in mind the living standards. The thoughts around factors like food, clothing, and shelter will be considered while defining these floor wages. There's also clarified that these wages may vary geographically, considering the differences in living cost at different regions. The wage definition, the most important change in the code, has been discussed across. Very simply, the expectation is basic plus DA plus RA, which is DNS allowance and retention allowance if relevant, should be minimum of 50% of the employee CTC. The thought is very simple, that if you have allowances, the percentage of which is more than 50% as compared to a CTC, then the additional or the excess over and above 50% shall be considered as a deemed wage and shall be added to the calculation of wages. It will have a direct impact on a lot of benefits. We'll talk about it in the next video. Working hours, very simple. The expectation is that the week cannot exceed 48 hours. Every employee can spend maximum of 48 hours as a regular working hours. We're not talking about overtime at this stage. A regular working hours, not more than 48 hours. Now, there are flexibility given to employers as well. Employers has an option to choose a 4-day working or 5-day working, and they can have their daily hours aligned to that, still ensuring that the work week cannot exceed 48 hours. Now, there are also discussions around overtime payments. I mean, this is not covered in this 2 code, but the thought is, as against, I mean, similar to the earlier laws, it has to be paid twice or 2 times the regular wages. And then there are rules around intervals, the rest intervals. It is very clearly indicated that there has to be 12 consecutive hours of rest before the next shift. Timelines are also very clear and stricter these days. So, I mean, although the timelines was defined earlier also in other acts, 7th or 10th, now it is very clearly indicated based on the frequency of payments. It has been defined as daily. If you're paying on a day-to-day basis under shift, it has to be paid immediately after the end of the shift. If you're paying on a week-on-week basis, it has to be paid before the weekly holidays. If it's on a fortnightly basis, it has to be paid within 2 days from the end of the fortnight. And if you're paying on a monthly basis, you'll have to pay on or before 7th of the next month. Now, there is an important thought process. We'll talk about it. That there is a practical discussion that we were talking to one of the clients. We'll speak more on that in the next few minutes. Very critical change. Employees who are separating, terminated, or leaving the organization, expectations are the settlement should happen within 2 working days. Now, this is a difficult activity that has to be managed by HR operations. We'll spend some time here, but it has to be thought through on how do we manage adherence to this requirement of 2 working days, because people keep on leaving. The due dates or the last working days are different. You can't have payments done every now and then from a finance perspective. So there has to be a practical thought around it to be managed. And the last important provision that we would like to speak on code on wages is indiscrimination. So there were rules that talk about parity of wages earlier as well under equal remuneration, but there were open-ended provisions earlier, which now has a clear understanding of discrimination based on gender in recruitment wages and conditions for similar work is prohibited. So we'll speak more. There is certain set of questions on this as well. On code of social security, one of the important coverage is inclusion of gig and platform workers. There are discussions around creation of a separate social security fund for the same. Now, that will ensure a lot of benefits getting extended to people who currently does not enjoy any benefits because they were excluded or not covered as a definition of worker itself. One important change, again, for FTEs, fixed term employees, a lot of companies used to hire fixed term employees and they end up not getting important benefits. Now, especially for gratuity, the rule has changed from 5 years of service. It has reduced the eligibility to completion of 1 year of service as well. So it will ensure that with 1 year completion, FTEs will start becoming eligible for gratuity as well. The central government has now required a national database which will mandate all unorganized workers, gig and platform workers to register. They will get a unique identification number, and that will help them migrate from one employer to another employer, or enjoy the benefits during migration from one state to another state as well. ESIC coverage extended to Pan India instead of certain scheduled locations. One important change is employers who are engaged in hazardous occupations, it will be applicable to them if they employ just one person as well. So with one employee, the ESIC becomes applicable to such companies. One interesting provision that has been brought in is commuting accident under the Compensation Act or under the Code of Social Security, which covers one of the chapter 6, I believe, on employee compensation. It is indicated that an employee, while traveling from home to office and office back to home, if he meets with an accident, now this can be considered or treated as an accident occurring in the course of employment. Now, it will have a significant implications of a lot of organizations. Now, this becomes making an employee or their family eligible for compensation or benefit. So we'll speak more on that, but this is something which will have to be dealt with in detail. Employers will have to understand more about their insurance coverage that they have been taking and the questions around what will happen if accidents happen not because of anything but a problem which employee or drink and drive, what will happen in that case? So these are open-ended questions which needs to be discussed further. And for maternity benefit, the work from home options after and then crash facility allowance for establishing more than 50 employees have been talked about. So these are key provisions. Now I will jump to the questions. So these are, we have looked at these provisions ourselves, thought of what question that can come to you and has been discussed by our customers as well. And we have tried to speak on those only. A simple question, a lot of discussions are happening. And Madhu, I will request you now to pick it up. Are the codes applicable, or we as employers should wait for rules to be notified? And this is an interesting question, but very important to understand.
Absolutely. Thank you, Sandeep. Thank you for having. I see participants going up by every minute. It's already 1,000 crossed. Thanks for all of you showing interest. I know it's very important topic, and then we all are, and it's impacting our lives, going to impact our lives quite critically, and therefore we are keen. And the most important question is, has it come into effect, and if it has come into effect, by and from when, right? So the by the structure of how the codes are enacted, some of the sections then, and also the notification. Let's be very clear. The codes have been implemented, and most of the provisions have been implemented with effect from 21st November 2025. Because if you read the notification, it says, as per section 1.3, there is the same section in all the codes which talks about central government by notification appoint a date on which the course will come into effect. So that's exactly what they've done. They said the appointed day for this code to become effective is the 21st November 2025. So let's not have any doubt in our mind that the codes are already in place and most of the sections are. These rules being notified is one of the important requirements for the code to be implemented, because we all know practically to comply with many of the provisions we might need the guidance of the rules. And these rules, labor being concurrent subject, and there is definition of an appropriate government in all in all the courts. It is incumbent upon the states to come up with the rules, and that will decide on how do we comply. But we also need to be mindful of the fact that every code has a few sections where they clearly mentioned as per the rules to be notified, or as per the directions to be issued, or as per the threshold to be gazetted by the appropriate government, or some sections only central government can notify, right? For example, interesting example is the maternity benefit crash rules about crash. Earlier in the Maternity Benefit Act was amended to include crash in 2017. The state governments were the appropriate government. They were waiting for the central government to notify after the amendment, and then finally central government has to send a letter to all the states saying that, boss, it is you, we are not the appropriate government. So that confusion is gone. But in this code on social security maternity benefit sections, very clearly for the certain aspects, it is the central government who can publish the rules. I'm just digressing, coming back to this thing. So only those sections which mention that as per the notification, as per the rules to be notified by the appropriate or the central government. Every other section which doesn't depend on the rules to be made, it's effective, it's already in place, right? And you mentioned an important exclusion in Code on Social Security, which is EPF Act. So what has happened? The subsumed acts, right? In this case, we are talking about 9 plus 4, 3 today for the both course thing. Out of that, only one act, which is EPF Act, the central government has held back from notifying. We will discuss the reason. So if, for example, whether new wage definition has come into place, yes, it has come into place. If as gratuity act has been repealed, it has been repealed, it's not no longer in existence. So if the very critical question is, if I were to leave, if I'm an employee, if I am to leave, today is my last date, or even 30th November was the last date, the gratuity should have been paid based on the new wage definition. This is very clear. And government is also clarifying this. I don't know how many of you were on the Deloitte webinar immediately of the course of the thing, where the joint secretary himself was there in the call, and he has also said the same thing. Couple of days back, I was also part of a CII and MOLE interaction on how do we ensure the implementation and smooth implementation. The same questions came up. Department, ministry officials were there. They reiterated the same thing, right? So all those sections which doesn't need rules to be in place. And what are these sections that need rules to be in place? We need to know in what form we need to maintain our registers. We need to know in what form we need to file our annual returns. We need to know how do we apply for contractor license. We need to know how do we apply for factory. These are all where rules are very critical, right? So from that perspective, the rules are not really the thing. So what happens to existing rules? Existing rules again provided in all the four codes in the transition section, which very clearly says all notifications, rules, orders, etc. issued under the repealed law, if they are not in total contradiction to the labor codes, then you will follow the existing rules. So there is no doubt about it, right? So clearly, I'll give you an example. Payment of Bonus Act, we need to file an annual return, right? By February, and existing current Payment of Bonus Act, only central government can come with the rules. And then central government has very clearly, a couple of years back, notified saying that you'll have to file that on Shram Suvidha portal online before February 28th or 29th, as the case may be. Which means that we have, if let's say by February 28th or 29th, no new rules concept, we don't know how to do it. If we file that form, we are compliant. That's as simple as that, right? So let's be very clear about that. Having said all of this, is it written in stone that 21st? There are representations which have gone to the government through forum and definitely through CII, which I know I'm personally involved. And I think the government is considering that, and not only CII, everybody is represented, because it's too sudden a change for something like gratuity to be implemented. So probably they are looking at it, but I am not very confident that something really big change will come, because there is no provision. There is a provision which says that to remove difficulties, central government is empowered to come up with a notification. But can that notification be completely against the spirit of the law is the thing. So we'll have to wait and see. So short
Right.
answer is codes are in place. Rules are matter only for those very, very practical procedural compliance. Otherwise, they are in place.
Thanks, Madhu. So it is very clear that now we have to look at provisions which does not require rules, and we have to ensure that cognizance are taken care to actually implement those sections which has no relevance to rules as well.
Just to add there, yesterday there was this big news flash saying that some unions, or I don't know who it was, I don't want to speculate, took the matter to the Delhi High Court. Delhi High Court heard in detail, and then they have asked. People are thinking it has been stayed. It's not been stayed. The only thing that High Court has asked is, please let us know what is this thing, because uh, the the rate petitions focus is saying that, boss, it is industrial disputes. There are so many forums in which so many disputes are pending, and suddenly you have created a vacuum. That's why my mention of this thing, whatever is existing under the existing laws will continue till the new one is replaced by the rules, right? So in this case particularly, the I tribunals or existing labor courts which are existing, they will all continue. right? And when they published the new infrastructure of dispute resolution, which is reconciliation officer, we will address it in detail, reconciliation officer, industrial tribunal, and national industrial tribunal, or probably starts from grievance redressal committee within the company employer, and then starts with that hierarchy. When they publish, they will also definitely notify the how does it all switch over to new tribunals, or will they continue in existing forums, will all be considered, and then we will get details about it. So there is no vacuum as such, is what I'm saying.
Okay, great. Now, I think this is a question that I've heard from a lot of people, because I think wage definition has changed. It is very clearly talking about basic plus DA plus RA should not be less than 50% of CTC. Now, what is CTC? I mean, this is a question which probably an employee might also have, an employer in the HR fraternity also might get confused. But how do you calculate CTC? What are the inclusions or what are the exclusions for that?
Yeah, I already saw in the chat quite a few questions. What is the definition of CTC? See, I think I spent so much time, donkey's years or probably elephant's years in this industry. And this whole concept of CTC is not, there is no legal backing to it. Okay. So you like to look at wage definition, forget about CTC, gross, and all of this stuff. Just look at the wage definition and what comes to be part of included definition. I just want to add a small note on in your slide. You said that three basic DNRA, but the inclusion part is so wide because it is anything that can be expressed in money and paid for performing the job, right, is to be included. So even a special allowance might come under the inclusion part, and might, as far as I'm concerned, it will come under that. I think we have examples on gratuity discussed. We will do that, but that will come under the this thing. So I think we should just not just forget about CTC. Just take your compensation, this thing, individual employees, probably the compensation structure or from your this thing, and plot your, okay, how much is the basic I'm paying, how much is the DA I'm paying, how much is the, if we are retaining allowance, how much is the special allowance I'm paying in the inclusion part. And exclusion parts are very, very clear, right? The bonus, uh, cash equivalent of housing provided, PF contribution plus interest. Then there is travel and conveyance allowance. Then there is
HRA.
HRA and any allowance paid to defray the expenses entailed on the job, right? This is a, while it might sound very technical, but it's very simple. Any allowance, let's say that employees work involves making too many calls, and then you are providing him a telephone allowance, will come under this. We give a very simple example, right? So you please plot that against this. Now, one of you, all of you might say, no, we don't give that. Now we give on entire CTC number. The employee chooses to take allowances, whether he takes or not, and whatever is the balance will go and sit in the special allowance. Be careful about such arrangements, because the special allowance that goes and sits, because it cannot be defined as an allowance paid to defray a special expense related to the job, you have a big problem coming there, because that will be added to the gratuity. So I think there is no legal definition of CTC. CTC is a concept invented by by us in HR, just to say, okay, this is the going to be, and we thought of including everything there, right? I will include gratuity cost notionally, because gratuity cost, how do you include? How do you to know today if this person leaves, this much is the gratuity? Because that's depending upon what his salary is, when he is going to leave, what is the final salary is going to get. All of that is there, right? So you really can't fix that, but you people have chosen to fix it, right? So that is no relevance. The relevance is what are the included components, what are the excluded components. You need to clearly plot it. If the excluded components is more than 50% of the total of both, then there is a flow back into the wages to calculate all your labor benefits, whether it is social security, whether it is maternity, whether it is leave, right? So I think let's not, there is no point in, you can continue to calculate a CTC the way you do it, but if you want to arrive at what is the wages within quotes for all your labor law purposes, then you need to do this Excel sheet and then be sure how it is tracked.
Sure. Just a small question on that. When you say we should consider all the included components, if the sum total of included components exceed 50%, am I okay to actually restrict the benefit calculation to 50%?
No, you cannot. You cannot.
I
You
cannot.
unless otherwise you really do the restructuring and then split those allowances which cannot be part of excluded. Then you need to split, recalibrate them into those kind of allowances which will meet this requirement, and then you need to fit into those 6 or 7 items which will be part of excluded allowance. Otherwise, the gratuity base, for example, will be including all such allowances, which can be. I've been inundated with requests from clients. I've been going through some of the structures. They are really high. They are really high. For example, my son. I'm giving his example. I don't know if he keeps hearing anyone these days. He's going to come and I mean, scold me. But I'm saying they have given a package which is basic. They have decided HRA, everything else they have given it in a bouquet of allowances, and it is for him to choose, and he has not chosen anything because he is following the new IT this thing, right? So
Right.
IT regime. So since he doesn't care what he's getting, so what's happening is more than almost everything is flowing back into the special allowance, which when I see it, I'm saying, boss, don't resign till 5 years because you've got a bounty of gratuity coming your way because your gratuity base has gone up so much. And while I'm laughing, that's the cost at which employers live. They need to be really smart about it, quickly go back and then see whether they can limit the damage to bring it to that 50.
Okay. So I think the simple explanation to this is from an HR perspective or an employer perspective. If you have to restrict your liability, you have to restructure to ensure that
Yes,
manage to 50% under included components and the rest has to be designed under excluded components.
correct.
Okay, great. Hope this answers a lot of questions. I was also not clear about this. It's clear now. I think this is something which I keep hearing also, but what is the difference between these two definitions, employee and a worker? I mean, how will you, I mean, if I have to understand whether I'm a worker or an employee, or I have heard a lot of discussions around a tech company, there can be a coder who can become or classify as a worker as well. I think these are classifications, whether it is clear or again, there are some gray areas around that. And if so, what could be the implications of different interpretations of these definitions?
See, I think what has happened is it's become very clear. Okay. As of now, you didn't have a real worker as a definition in many laws, but workman under the Industrial Disputes Act under Section 2, I think it is 2S, was the very critical one where it said that any supervisor earning more than 10,000, other than that, everybody else is a worker, right? So the 10,000 rupees has become a kind of a norm. So everybody assumes that anyone who is drawing more than 10,000 is not a worker. That's not the case actually. Supreme Court has been very clear. There are quite a few industrial tribunal decisions itself which is saying that, but somehow that has gone and set into our mind. But now it's very clear the same definition across all four codes, right?
Okay.
Employee is everybody. Even if any you have an employment contract with the company with an employer, then you are an employee, right? Now the people come and ask me, what about my consultants whom I have engaged? Be careful about that. Consultants are not employees. Consultants, you sign a contract for retaining them as a consultant for their expertise, and then you pay them a fees, or you pay them you don't call it a remuneration in the normal this thing, right? That's why they are consultants. So you don't, but unfortunately, most of the time it is hired. They are consultants on the paper, but they work as employees. So the danger with them tomorrow, they've only coming back and saying, I for all purposes, I'm an employee. Please pay me gratuity is a possibility that is still there. That has not gone away, but we will exclude them, but other than that, everybody has an employment contract as an employee. It can be Madhu, who was a general counsel for a large company. But even I was an employee, or I will be an employee if I'm part of the this thing, right? So that is clear. I think with that, what happens is worker is a small section of that, or
So
probably
worker is a subset of employee.
subset of employee. So every worker is an employee, but not the reverse,
Sure.
right? And therefore, who is a worker? The employee who is not a managerial or administrative, who is not performing managerial administrative tasks, is clearly not a. So if you have a manager who's managing a function, you managing a this thing, there are people reporting to him and all of that, then he is definitely not a worker. And a supervisor who is drawing more than 15,000 in code on wages and who is drawing more than 18,000 in code on IR and OSH is also not a worker. So any supervisor drawing less than these thresholds will be a worker. So which is why people are now asking. So I have, let's say, an accountant sitting in my office. He draws 50-60,000 rupees, and but he is only an accountant in the sense that he is okay. Accountant is probably there is
He is
a
an individual contributor, not a.
individual contributor. Let's say somebody who is just managing accounts payable, that he just takes all the invoices coming in and then he verifies and then he posts for payment, right? He doesn't exercise any discretion and all that. There is every possibility that such a person will be a worker. You need to be very careful about that. That's where I didn't go to the extreme example of IT coder, but I'm just giving a very,
No, I
very
think this is very simple now. So
yeah.
everybody who is an individual contributor, right?
Be careful
And I
about
think
that.
there was one more discussion you mentioned about administrative activities. So I think
Yeah, correct.
how do we see administrative
Yeah,
activities?
so I gave this example last time. So I think that example is relevant. Or even today, they were asking me what to do with our call center. They were call center just specifically for their this thing, and that's a separate establishment by itself. There again, the pushback to me, I was thinking call center is a very simple example because call center, they come, work for 8 hours, they just take calls and go. So they're workers. Where is this manager?
Absolutely.
How much ever get paid doesn't matter, right? But then everybody is throwing that question back at me saying, no, 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 these guys exercise a lot of discretion. For example, it could be a sales, outbound sales, this thing. So they have a bouquet of products, they have to understand and then explain to the client, and then they have to take a discretionary call and all of that stuff. I am still iffy, but probably if you are having the documentation to support that they are doing administrative jobs, administrative tasks, then you have the right to do it. So what we all need to be careful is, if you want them not to be workers, it is not enough to just say I'm paying them more money and all of that. You are giving them fancy designation, but it's on paper what he does it amount to a managerial or supervisory, I mean managerial or an administrative task. If you can do it, then you have a fair chance. Why is it important? Because worker decides a lot of downstream compliances. OSH code, for example, code on wages is only about employees, so don't worry about worker. And code on social security, the two acts today, codes that you are discussing today, that also the same. Employees, it doesn't matter about. So every employee is eligible for all these benefits. Only thing that might cut them away is the thresholds that has been prescribed for each of the this thing. And when it comes to OSH IR code, it is applicable only to workers. So formation of union, recognition, whether you have to set up a GRC, all of that, it'll all depend on whether you employ or you want to have a standing order. It all depends on whether you are employing workers or not.
Okay.
So
So you are indicating that the of appointment letters or the documentation that we have for a
yes,
person who is
yes.
employed has to be very clearly, thoughtfully designed so that we ensure that they do not get categorized as worker from a definition
Yeah,
perspective.
it's no longer enough to give a very
Generic appointment letters.
generic appointment or a generic this thing. You
Mhm.
should have a probably a proper annexure of what is going to be his job description. And
GDs
then,
have to be added to that.
yes,
Okay,
yes, and
great.
bring in that element of managerial and administrative tasks and all of that into the appointment letter itself.
Great. It would be a big task for every company now. Okay. So I think there are two discussions, two questions linked to each other. From a curiosity perspective, we just wanted to understand, is there a time frame by when we will look at national floor wages getting introduced?
See, I think government is already at it. If you look at the one of the first section to be implemented of code on wages is the section about constitution of Central Minimum Wage Advisory Board. This was done in August 2020 only, when the discussion was going on. And I for sure know there was a 2018 committee which was appointed to come up with the national floor wages. In fact, they have completed the report through VV Giri Institute of Labor. They also presented it to even They came to CII IR committee meeting and then presented to us that 6 regions has been split, and then for each region they have arrived at a this thing and all of that. So government has done a lot of work on it. Then they reconstituted the committee in 2020, and I believe that they have gone through multiple deliberations. They are almost ready to come up with the national floor wages.
Okay. Okay. So we can expect it soon.
Yeah.
Now, there can be one more question, that may be a hypothetical question, but what if the state governments do not align? So
If they
what
don't
are the
align
things
above the minimum, above the national floor wages, nothing can be done. But they can't align below the
below it? So you'll have to ensure, irrespective of that, national floor wages will be considered.
expectation from the industry, right?
Industry.
I was there in the room with the ministry officials sitting. There's a lot of us sitting from the industry side in that conference, and the expectation from the that room from industry was that this will kind of give a national number or multiple national number depending upon the region and sectors, and above which states might hesitate to this thing because they have a political defense. Center itself has president, why should I go more than that? Right now, what's happening is some states like Karnataka, it is really high, and already high one is now there is a draft proposal waiting. I was part of the minimum wage advisory board in Karnataka representing CI, and we know that they are proposing 24,000 rupees as the starting point. And that is for at some of the cases 3 times more than what is there in neighboring states like Andhra, Tamil Nadu, and even Kerala. All right. And
Okay.
so those kind of disparities probably might go away. I may not go away, but at least states might think because it becomes non very uncompetitive, right? For example,
Correct.
the
Correct.
industry
If you
will
want to attract labor, you'll have to be
labor and all that. So, so hope is that the national floor wages will bring in some kind of sensibility to states and not during closer to election just increase the minimum wages higher and all that stuff.
Absolutely. Absolutely. I think this is a favorite topic a lot of HR folks are now talking about. Should I or should I not restructure salary now?
Yeah, so that's a very important question because, for example, now 1st December onwards, you suddenly change your this thing so that you bring it to 50. There could be a question as to you have done it only for the reason of reducing your cost because of the law has changed, right? My answer to that is while yes, there is an element of what you call right or not right about it. The employer has a prerogative, and then employer has a prerogative to change the wage structure. I think they can change it. My only worry would be when they split that special allowance and those allowances which don't fit into the exclusions, they shouldn't do it in a very, what do you call, a very mechanical way and then say these are all gone, right? Then it is a giveaway. Probably you should spend a little more time, thought, and say design allowances which will fit into those the expenses, I mean, to defray expenses entailed on the job and all of that, and then design it. Probably you even if there is a challenge, you will be able to work through it. But this question is being asked of me, and I did throw this question at the ministry officials. How will they look at it? They are saying, boss, I think if you as employers go beyond a certain point, there are checks and balances in this country, which they meant that people will take you to court and then it will get decided. My sense is, my reply is that you have every right to do it. I think you should attempt to do it. When you do it, be careful about how you are getting it done and then how you are communicating this to employees is very important.
Right. And I think one more question I think I would personally like to understand is when we should do it. I mean, should we do it now, or I think we can defer it?
No, I think considering the impact of gratuity in some of the very skewed structures that I've seen, I think it is high time because some employers are coming and telling me for an employee base of about 3-4 thousand employees, let's say an IT company and all that, actually estimated liabilities coming to hundreds of crores. And
Okay.
and if they don't really do that, that will be a big hit into their books. So
So, I mean, every company on a case-to-case basis understand what is the current structure, assess in depth on the implications of this under different heads, and reassess on the
I was
relevance.
with a client yesterday, and they have shown me, and then they also been very smart. They have kind of gradually increased it. Now they're close to 45%.
Hmm.
right? Which means that the every increase, every year that actuarial valuation has already been done, that impact has already been considered. Now they have to do only that minor 5%.
Fine. So I think a lot of companies have seen, not many, I would say, but still they have actually started uh, planning or preparing themselves to implement this code. So as you
So
rightly
to
said,
that extent,
from
now the
30% to
CHRO and the
45%.
CFO is telling me, no, Madhu, this five, I don't want to make it look like I have done something after
Mhm.
this change. So I will wait for April, right? But
Right.
then that comfort comes from the proactive act, this thing they have done.
Correct. Correct. I think there's one question, though, although overtime is generally part of the other code, since we have spoken about working hours, is there anything on the maximum overtime hours that is allowed? So 48 hour is a normal working week. How much extra can an
So
employee be
this is
made
where
to?
the employee and then code being applicable only to employee. But there is one section which is just the cut paste copy of the Minimum Wages Act section, which said that which talked about wherever minimum wages is specified, and if that particular in that particular scheduled employment anybody were to work beyond 8 hours and all that, you'll have to pay overtime, right? Now, because the fact that minimum wage is not for a scheduled employment, it is for all employment, right? And the fact that the section still starts by saying for wherever minimum wages has been notified, then an employee works for more than 8 days, overtime wages have to be paid. Now, we'll have to wait and see. One comfort which I get is that the central way code on wages draft rules, when it was published, there was a schedule which had some 500 job descriptions for which are job roles for which they are going to prescribe minimum wages. So there is going to be at least job role wise specification where minimum wages will be notified. So probably we can take that stand. So this particular employee, there is no minimum wage is or he is paid far above minimum wages. So this particular section is not applicable is a possibility that we can defend ourselves. If that is the right stand, I am just put that if out there, then the overtime will be applicable only for the workers under the OSH code.
Okay, but I think one of the questions that is floated
Yeah.
is there a limitation on how many hours I can work as overtime in a week?
Yeah, so there is this thing, the 48 hours and 8 hours per day and 48 per hour week. So anything above that you need to this thing. There are weekly caps, quarterly cap, monthly and quarterly caps that can be prescribed. So that we'll have to really wait for the rules to come.
Fine, fine. So that it will be driven by rules then. Yeah. Now I think this is uh, something I am also not sure, although I have done a lot of work as process management in corporates. How do you manage 2 days salary payments for separating employees? I mean, it becomes very difficult.
This
What
is
are your thoughts on that?
this is going to be a problem, but comfort that people can have is that it's only about code on wages. So only about the wages. It is not about other benefits like your leave encashment.
Gratuity and all of that can stay. Yeah.
But leave encashment, if he is a worker, the OSH code has very specific provision which say the leave encashment also has to be paid within 2 days of exit.
Oh, okay.
Okay, so there also your ability to keep people away from being a worker will will really matter. So the requirement. Then there was a question also on the chat I've seen. Is it that when does the 48-hour clock start ticking? So when the central rules came draft and multiple states just copy paste the central rules, we had given from CII and ISF and all of that inputs saying that please be clear when the clock starts. Make it saying that he has completed all the F&F processes like return of assets and all of that, and from there make it 48 hours is what is the request. Whether they had considered it or not, we will have to wait and see when the rules come.
Okay.
Otherwise, it's going to be a problem. You need to
I
be
think one simple way is to actually align your HR policies around that. I
correct.
mean,
And the
practically, if I
process.
have to implement in my company, I could simply say that your last working day, when you're agreeing with an employee, it has to be the last working day of a month rather than 2 months or 3 months or 1 month.
True.
So,
I think planning will definitely solve this problem, Loy.
absolutely.
Today morning, I was on a webinar with a payroll company, and then all of those people who are managing their clients' payroll, they did have their own concerns. I think there you,
Mhm.
as you rightly said, you will have to be very clear as to with your client also, boss. If you want me to be compliant, then you need to reorient your process and then help me keep you
Absolutely.
compliant.
Correct. And One more interesting question. So I think this is something which I have personally, one of the client spoke to me on that. If a company adopts a different attendance cycle, not 1 to 30, but like 21st to 20th, the timelines for payment, the payment of wages, is it okay in such case when I'm adopting a attendance of 21st to 20th, I can pay on or before next month 7th?
See,
Or I'll
this
have to
is
actually ensure that 20th is the last date. I'll have to ensure the payment has to happen by 27th.
Yeah, so this is not a new problem. Even earlier, also the payment of wages had the same issue. And see, this is something like again CTC concept. This different attendance cycle is not something in the law, right? Of
Okay,
course, for the convenience, as the employers become larger, more and more people are being engaged and all of that. You did have that. Otherwise, it's very difficult to adhere to. The way I have argued out earlier, for example, in some inspections and all that it came up, I have argued out earlier was, boss, that's attendance cycle for me. See, if let us say it is 21st to 20th of we are in the month of December, for paying December salary, the cycle starts from November 21st to December 20th. That's
correct.
attendance cycle, but the salary is for month of December only. Correct. So, and then what happens? You are not considering 10 days. No, it's a cycle. So by next month, when you do it, it's automatically will also take, for example, the February cycle. By March, it will take care of the 28 or 29 days as well.
Got it. So I
Right?
think we are trying to indicate the wage cycle. Wage month is different from attendance cycle, and we
Attendance cycle.
continue to look at wage month.
Yeah, if you don't do that, this will become a very problematic. I don't think practically it is possible.
Great. Now, another question. I mean, I'm sure there is a possibility with this new code on gender indiscrimination. Do you think it will lead to more litigation, or it will reduce litigation?
No, see, the code has multiple options for disgruntled employees. Okay, I'm saying, but then if you are the Equal Remuneration Act with all its 20 sections really didn't achieve equal opportunity thing. But I think the with one section, it's clearly been achieved, is what I would say. Because
Okay,
one, it is very clearly brought in all gender. It is not only the two gender earlier. Second, it is not only brought in, earlier one was only about wages, right? Paying wages. It is about even in recruitment, you cannot do it. And because this law has come in, suddenly you cannot reduce somebody's salary also, they have said. So multiple dimensions, I think they have ensured that it is an equal opportunity as well, right? Now, so if you are not following, if you leave a possible evidence in the hands of an employee, then it could be a possibility. And we also need to know, as a economy, as a nation, we are getting modernized, and also these things also will come up. People will, and with a generation which doesn't really care about loyalty and all of that, and we need to be very
absolutely,
careful about how do you want to do
absolutely.
it. We need.
Employers will have to be very careful. I mean, again, the JDs and the work descriptions makes a lot of difference then.
And which is only right, right? So if a particular gender is wanting to assert its rights, and then we are not really taking care of that in our normal employment processes and all of that, I think then such an employer deserves to be faced with
Absolutely,
consequences.
absolutely. Now, I think we heard somewhere that there is for gig and platform workers, there will be a social security fund. So, are we saying that the provident fund will not be applicable to them, or will it still be
No,
applicable
no.
to them?
So the gig essentially how it works is the if you look at the definition of gig workers and platform workers, it very clearly even from the place where aggregators and what is a platform, everything is defined with a clear mention in all of them. It is all work arrangement which is beyond employer and employee. Okay. And there is one operative section, section 114, for example, with respect to gig and platform workers, which propose only the central government to come up with social security schemes for them, which can be about old age security, which can be about accident insurance, which can be about job loss and all of that stuff. So all these sections, so they, and then the same section also provides for essentially saying the contribution towards such schemes will come from aggregators at a 1 to 2% of their turnover, and
Correct.
at the gig or platform workers level up to 5% of the payout to them, right? So it will be a totally different scheme. And being inside of a expert committee which was constituted, I was representing CI in that under the chairmanship of CPFC for structuring the scheme, which went through a lot of, and it had a lot of representatives from gig unions as well. and all those inputs were taken, and then there is a scheme in the works which will definitely say they may have a PF portion to it. EPFO may still be the administrator for the scheme, which EPFO is getting ready for in a EPFO 3.0, but that will be totally different from the provident fund we know
So
for the
it will be over and
employees.
above the PF.
Yeah, it will be over and above PF.
Okay. And I think the last question, again, I think I mentioned that commuting accident, I mean, including this again makes it complicated.
Yeah, so I think it is kind of very interesting provision added to take into account multiple decisions of the Supreme Court, because there is this concept of in the due course of employment. So
Right.
where does it start and where does it end is what is now very finely included, defined and included in the law itself. Earlier, the whether it starts from the time I leave for work from home until I return home after the work is what Supreme Court has tentatively agreed to. Because Supreme Court has said, why is he leaving home? Because for work. So if he meets with an accident, right? And there were multiple variations in case laws which said that while he was on his way, but he went to attend a wedding and came from there, right? So where this that start, right? And I believe after morning discussion, I just was checking around with some of the insurance company. I believe this got too technical, and some insurance companies defended themselves, saying this is even with the commuting this thing, this doesn't fit into the due course of employment, and they were able to win the case. So I think Supreme Government of India thought, let's remove all the doubts. Commuting accident is also included. Is the thing, but you know what? This will have probably an impact from a perspective of now workman compensation insurance, right?
Absolutely.
So
Cost will go up for insurance. Yeah.
they might even start asking how many people drive are
Absolutely.
in your
So
population, how many
do
people
you have public transport,
bike.
private?
Yeah, exactly. So which used to be a
It may be linked to your
very
individual
nominal
insurance
sum
also.
might become little more complex going forward, and you will see insurance companies asking for far more details to cover.
Absolutely. Absolutely. So I think we'll switch gears. What is more important is we'll spend some time on the impact. So I understand we have reached 1 hour, but I'll rush through it. So I think from provident fund perspective, I think we broadly spoke. So I will skip the slide. We spoke on the inclusions and the exclusions very clearly in the past slides. So discussion. So I'll take on to it. I think what we have tried and do is see the impacts, assuming that in future it is taken care of and it's now active, what will be the implications? Now I've taken some scenarios, employees with higher salary and they've continued the wage ceiling of 15,000. There is no change. Nothing will change from an employer perspective, nothing will change from an employee perspective. It remains as today. The only discussion is when you actually contribute to PF at actual, which is 12% of the values.
Right.
Now, what do you think there is a possibility?
So I think
Chances that it
if
will
that
increase?
actual wage is above 15,000, as you rightly said, there is no impact. Employers should not worry too much about it. They shouldn't think that no, I'm bound to increase because my wage has gone up, because 15,000 threshold, only when the threshold changes, they need to worry about. But if it is less than 15,000 and then you are contributing, if your structure is not very skewed with a very low basic, then this impact will be definitely coming. But if the structure is proper basic proportion and HRA and all of that, then because of the Vivekananda Institute judgment, we are including now everything into the PF wages. And therefore, we are paying almost on entire, like ESIC, almost on the entire wages. Probably there are opportunities there to look at, and then maybe you will reduce your contribution, and there could be an impact on take home also on the employee side, because he will also contribute that much lesser.
So are you saying this the Supreme Court judgment now will be relevant with the courts coming in or with the
No, no.
definition?
So Supreme Court judgment is relevant to the definition of the wages under the 2WW, I think, in the PF code, right? And the see the problem confusion happened because that is there is one wages definition which is almost like the same what we are discussing today, and then section 6 which said that you have to pay contribution only on basic plus DA. Right. So
Correct.
then
That's the
EPFO
confusion.
interpreted based on age definition, employers interpreted based on section 6. So it was in that context the whole judgment was. Now that it is so clear here, I don't think it is really, it has its own impact on this thing. But except for the fact that special elements and all of that, the some of the jurisprudence which has evolved, whether they are excluded or not, the same Supreme Court argument like incentive, whether they form part of this thing, we can use it for justifying whether they are included or not included.
I think there were some questions around it. I think we have broadly spoken since the PF is not yet repealed.
Yeah.
I'm assuming that it will be as and when it gets notified, it becomes relevant, right? The new part.
I don't expect that to be too far off. Before April, I think that will also be done.
It will also happen. Okay. And these are our thoughts. If you have to actually prepare yourself, I believe that reassessing the existing structure and working on to align with wage definition, communications, and updating your payroll systems is something that we have to continue to work on so that we are not too far when we have to start preparing for it. So these are homeworks that we have to constantly do. Now, is there a possibility? I mean, I think these are random questions which keep coming in. Can employee raise a complaint for changes to the structure?
Yeah, the same logic that I said about gratuity, and also they can, right? Even an PF inspector can walk in and say, you have just changed it because you wanted to reduce PF and all that. But I think that is provided for law. So I am trying to meet the law.
It is aligned as per the law, so should not deviate from, right?
Yeah,
now, very briefly, in employee state insurance.
Yeah.
Overall coverage, we broadly spoke, all established in more than 10 years. It covers all categories of workers. We spoke on even if one employee is there for an establishment involved in hazardous occupations, it will be relevant. There is basically no rules yet defined. So I'm assuming that the existing ceiling of 21,000 continues.
Yeah, it will continue. I saw another question on PF also. I think reiterating that PF 15K also continues.
Okay. And ESIC now, since it's repealed, we believe that the calculation would be as per the new wages as against the gross wages.
Yes.
Right now, what is the impact? I think the impact is very simple. We now, since it's wage definition, which has to be included component, more and more people may actually become eligible for ESIC is what I believe. I mean, your thoughts on that?
No, I'm definitely there are borderline cases in between almost from 20 to 25,000 people, 21 to 25,000 where we consider them excluded because HRA is out of the contention, and suddenly and some of the other conveyance and all that out of contention for ESIC wages, you will have them all coverable. So here, because we believe it is already implemented, you need to be very careful because the day it comes down, he is ESIC coverable. So something were to happen and he should have been covered. Then if you're not covered, then you will not get the ESIC benefit.
Absolutely.
So this is something that the employer should be very careful about.
And since the basis is changing, we believe that the contribution per employee will be beneficial to the employer. The contribution will decrease, but since more and more employees becomes eligible, the overall cost might go up. Is the simple assessment, our assessment at this stage. Yeah. Now, the thought is very clear that it is applicable from November 21st.
Absolutely.
But the problem is from when I should start calculating.
Yeah, so I think November 21st came too late. I think expecting that to change from November 21st is not. There was also a question, no, ESIC, there is a minimum contribution period and all of that. Yes, ESIC, certain benefits has a minimum contribution period, but sickness benefit, when you go and if you're sick, you can get leave and then through that time, ESIC paying you and all that, there is no contribution period required to get the benefit. So there are certain things which you are eligible from the day you are covered. So this decision employer has to take quickly, but I would at least say from December 1st they need to
they should start looking at it. Correct. Because there is a requirement of 10 days also, right? And now 10 days is a confusing because 10 days is from the date of joining.
Correct.
Now there is no joining, is basically the day on which either
it becomes applicable to him. Yeah,
applicable to him. So as per our understanding, assuming that the restructuring doesn't happen, looking at the current exclusions and inclusions, if I become eligible on 21st November, I should have got registered by 30th or 10 days first. Right. So I think employers should work on it and take decisions on that. Gratuity, I think much on the gratuity, there are no changes on the broader applicability and the calculations and eligibility specifically for permanent employees. I think what has changed is only for FTEs, we spoke earlier as well. Impact is very simple. I think we are all clear that impact is increase in the liability. And that too, I believe, is immediate. Right? Is there any other thought? Gratuity will be applicable immediately, correct?
Yeah, gratuity, as I said, it's applicable immediately. You have to be careful about that. And when do you change and all that has its own implication from moral, ethical, and the legal
Mhm.
perspective.
So I think the question could remains that if a lot of employers who actually decide to wait and watch and have not restructured, you're saying that simply they'll have to look at the inclusions and the exclusions and then calculate the gratuity accordingly. They can't just look at the old thought process.
No, they can't. And I saw a question flash by on the chat, which is about should I continue to make provision for increased should I make provision for the
We
increase? No,
should.
because see, even if the government issues a clarity and all of that, the auditor will come and probably can
Absolutely. Absolutely.
if it doesn't. Because,
I think every company will have to take that hit on March,
yeah,
upcoming March 31st.
yeah, probably
Absolutely.
listed once by December itself.
December,
Yeah,
absolutely. Quarter end, they'll have to take that thought, but by default, without fail on coming year end has to happen. Okay, maternity benefit again, no change on the applicabilities and eligibility. It remains the same. I think what has changed is there is an extension to commissioning mothers. We
yeah.
already had biological and adoptive mothers in the past. Now commissioning mothers gets added, and I think again the definition, wage definition comes into picture because it talks about 3 months average
Correct.
subject to minimum wages or revised per new codes. So again, wage
So
definition
the
will come into
wages
picture.
definition might come in. I think you have, I think in the next slide you have the impact of that also. It unfortunately could be a reduction because today
Reduction.
what is generally employers don't bother about it. They just pay during the maternity, the 26 weeks, whatever was the full salary. They don't look at it as
Correct.
if the employee is on a leave and this thing. Here there is a possibility employers
So
looking at.
if employee choose to implement, then there is a possibility of reduced payouts to women. And although positive impact for employees, it may have a negative impact on the employees directly.
Correct.
Now, I think there was a small question which got discussed a couple of days back was if I'm already availing maternity benefit, I'm already on leave, it has to be now changed from 21st November.
Yeah, that's a very good question.
If the company chooses to, if they can.
Yeah, if you legally you cannot fault the complaint. It is by the letter it is right, but by the
Right.
spirit is it right or
Yeah.
it's for the
So
employer?
from our legal perspective, employers can do that. Okay.
But what if they've already paid? Sometimes that also do some employers
No, I
paying.
think what they have already paid for November is
Yeah.
fine. Let's say they may and they decide to adopt it from December. I think that was the question.
Yeah.
Okay. Compensation. So I think what has changed for compensation, it now aims to cover all workers, including unorganized workers. We spoke in depth on the commuting accidents that's covered now, added. Wage limit, so as per the new wage, there is no upper limit. Earlier, there was a limit for 15,000 from a calculation perspective. That is an important change. Or I don't know whether it will be driven by rules, Madhu,
Wage limit, no,
for
that
employee compensation.
more than rules, it will be these are all very specific by notification only they can change it of the
Okay.
specific thing. So the current notification will stay valid till the government changes it under the code. So we'll have to, till
Okay.
that time it will be
We'll
there.
have to wait. Yeah. And I think from a dependent perspective, they've broadened the definition. The maternal
I
grandparents,
think the wage limit is 21K, Sandeep.
sorry, it's not 15, it's 21K. Okay, fine. Now, impact is again on the same line. We believe that the cost will go up,
Yeah, because a very
right?
clear definition of, I mean, bringing in commuting accidents, I think the scope kind of goes up, and these insurance companies might easily
Absolutely. I
follow them.
think they will by default. It's an opportunity for them to earn because more and more cases will fall on them now.
Correct.
And I think these were I think questions which is more relevant from an insurance company, whether they can talk about owned versus public transport. I'm not adhering to law. I'm drinking driving, reckless driving. Is there a possibility insurance can deny? So insurance will deny because they have specific rules, but will employer has to pay?
That's a very good question, Sandeep. I think these are all, see, once these things become more clearer, then they get more,
They,
more
they
clear
have
as well.
more specific provisions then.
Provisions, right? The more, see, it's a good question. Let us say, probably when you may have to have in your HR policies also saying very clearly you are supposed to adhere to all these safety requirements, and then If you are not, then because for example, personal accident insurance, most of the employees take, which is not required by law, right? And there, when employee is given, you clearly tell them, boss, we have covered you, but in that, if you have not adhered to safety, right? Similarly, a factory floor accident where the requirements to adherence to safety is not adhered, irrespective of the whatever it is said, generally employers are, they don't really stick to it, then they pay, right? And they will end up. But if what happens if it is a transport between commuting accident, and it is really found that you didn't wear all the safety requirements, can the employer deny? I think if I very technically, the employer has the opportunity to deny, because
I think there is a section I remember clearly, 74(3), just below this section where it was defined as commuting accidents are covered as in the course of employment. It indicates very clearly that irrespective of whether an employee is adhering to law or not, is what I read, I remember. So that is an open-ended question from a future perspective.
So basically, in a factory floor accident, even if the employee doesn't do it, the employer end up paying, and insurance
End
companies.
up paying, absolutely.
So
Yeah.
same principle might have to be extended.
Applied here as well, right? I think the last bucket that we want to talk about, and then we'll go to the planning of what we expect corporates should do, is bonus. I believe there is broadly no change on bonus from an eligibility calculation, minimum and max rates. I think the only difference is wage definition will impact the bonus calculations.
Right. So
Again, the
here
impact.
also, because mostly the employers used to take only basic plus DA, now that you are going to take 50% and all of that, so there could be a possibility many people may fall outside the bonus threshold, 21,000. And
So
what?
assuming that they fall outside, the cost might go down. So again, you'll have to think through on how are you creating your structure.
Correct, correct. How are you creating a structure?
And I have been talking to one
Interesting
of
aspect
the
is
large companies.
the current 21K threshold is built into the employee definition, hard
Correct.
coded into the employee definition. But in the I mean, not current, the prior to 21st now,
Right.
in
Yeah.
the wage code, the section clearly says the appropriate government can fix this
Really.
threshold. So I hope states don't go create their own, and then there is difference between respective states. We
Now,
might
if different states come up with different thoughts, for an employer, it becomes very difficult to manage from
become
a
very,
payroll
yeah,
perspective.
yeah,
But anyway, so in principally, it might also depend on how is your structure design.
yeah.
It may ensure you may ensure that the structure is designed to actually cross the threshold, and then you end up paying zero bonus, or else you continue to pay higher bonus. Now, I think what we wanted to discuss, and Madhu, this is your expert opinion. What should corporates do to stay compliant or prepare themselves to stay compliant from a long-term view perspective? As you mentioned, there is just a matter of a couple of months when it will be complete law. Rules will be there and applicable. So
Yeah.
there are a few things that we have jotted down. I would request your guidance to my audience on that.
Yeah. I think we have listed correctly. Gap assessment from every aspect you need to look, right? You rightly put the salary structure at the second line, and then top priority is from a perspective of employee, worker, all of those aspects have to be looked at. All your documentation, employment contract, even for example, whether incentive will be part of your wages or not, will have to be very clearly thought through, and then accordingly your salary structure, which goes as an annexure to a appointment letter, all of them has to be very clearly looked at, and see whether any tweak in the language will help you to define these kind of concepts and all of that stuff. So yeah, gap assessment from all aspects, right? Existing your documentation vis-a-vis what the courts are saying, is there a way to kind of alleviate some of the issues and make it more clear in your documentation? HR policies, leave policies, all of that you need to look at. And second, of course, real immediate financial impact will be your salary structuring. We all seen it that you really need to look at what will be impact, particularly gratuity. And then you have, yes, once you do that, then the results are your revised employment letters, revised HR policies. The last but one is very important, where you are looking at contractors and third party agreements. There also, because the rules, for example, central rules on code on wages, since we are talking there, has a provision which says that to ensure that the contractor pays wages as an employer in time, the principal employer has to pay his bills in time. Right?
So,
So the earlier provision was in section 21 of the CLRA, if the contractor doesn't pay, it will fall back on the principal employer. Here it is slightly on the other, it is
on
kind
the
of reverse.
contract themselves, yeah.
So, what are your contract provisions and how is it working? And again, the fallback of, let's say, PF not paid by the contractor, it will immediately come to you as a principal employer, right? And gratuity, earlier there was no clarity as to whether the contractor as an employer, if he pays, can he mandatorily recover it, or if he doesn't pay, will it fall back on the principal employer? Bombay High Court and all that very clear. Is the contractor's responsibility between contractor and principal employer? It is not law that decides; it is the contract that decides. Now, since it gets subsumed under overall Social Security Code, and then the definition of the employer and the contractor is and contract labor is already brought into respective codes, that is not a question in doubt, because if the contractor doesn't pay, it will come to you.
Absolutely.
Gratuity. So you have to be very careful about it. So you need to look at your documentation, and particularly we will discuss OSH code, but particularly again contract labor is prohibited in core. From that perspective also you have to look at your contracts documentation with your contractor.
Right. And salary structuring, I have been talking to some corporates. I think it was really interesting to understand that different ways of structuring may actually help you reduce the overall cost as well. I
Yeah,
mean,
see,
it's
yeah,
interesting to
that's very bad.
understand.
I also missed. See, for example, most of the contractors issue FTE letter to their contract labor, and they
Absolutely.
don't bother. Client also doesn't bother, and they keep working. But just because the letter is FTE, he serves for 3 to 4 years. Then you will, if he leaves now he will be eligible to be graduate. Who's going to take?
Correct. And I think this will be relevant for a lot of staffing companies where they have not looked at this,
Yeah,
or the contractors who have not bothered about it. And I think a lot of them actually hires as FTEs also, hoping that employees understands this and then they go back to the employer for asking.
absolutely. Last but not the least is how do you restructure? How do you communicate to the employee? And see, yesterday I was there at the panel that HSBC's CHRO was there, and she made a very important point. It is not enough the IR and HR, ER people know this. It is the line managers who need to know, because they are going to go back. There are a lot of going to be a lot of suddenly why is my PF going up? Suddenly why everybody is saying gratuity has gone up, but my gratuity doesn't go up? All those kind of questions will come, and your every person who's critical, who's involved in interacting with your employee everywhere has to know what is this change is about. So, and since you are going to change employment letters also if it is required and all of that, every aspect of it needs to be very clear in with the employee, and your line managers, everybody needs to be trained, everybody needs to be informed what has changed, and they otherwise this will create a lot of confusion.
I can understand. I think during COVID days, I still remember the communications and becomes very difficult. So unless you plan it better, this can be a nightmare for HR fraternity.
Correct.
Right. So with this, I think Uthya, you want to look at the set of questions that we
Yes.
have, and
So
then
we still have about 850 odd people uh, patiently sitting with us. We've got about 200 odd questions, so it's obvious that I've tried answering a few of those directly. I have selected about 20 questions from this. I would request Madhu sir and you, Sandeep, to quickly answer those questions, as most of these questions have already been covered during the course of the webinar. But since the questions are still there, we'll still put it out. As the labor codes are, the first question, as the labor codes are effective 21st November, we've had some exits in December and wish to understand whether these people are supposed to be paid the increased gratuity or not.
I think I've already answered that. Yes, technically yes.
I think it was clearly explained by Madhu that yes, it has to be in gratuity calculation as per the new wage code definition.
Right. Uh, is overtime applicable for managers?
Now that's what I answered. Code on wages, the minimum wage is linked to overtime. but where minimum wage is specified in that employment, you need to. But then there is confusion because the biggest claim the government makes, and also which is true, is that minimum wage is no longer dependent on scheduled employment. So technically, it may be applicable even for employees, but we'll have to see, because there is also a schedule to the rules which talks about where minimum wages can be fixed, and then they have notified about 500 job roles for which it can be fixed. Now, if is it only for them where minimum wage is fixed, or is it for all employees? If it is for all employees, the question about managers to be paid overtime will also be true. But I think overall the law there will evolve, right? See, because anyone in that kind of a role is always paid much more than what is minimum wages, because this whole chapter is about minimum wages. And uh, the since it is so far above this thing, the assumption is that the need to work beyond requirement and all of that is already built into the salary structure, right? This is how the jurisprudence will develop, is what I am expecting.
Substance over form is what you're trying to indicate. Yeah.
But to get there, we will need a couple of disputes to reach almost up to at least High Court for get us to.
So you are saying some disputes should come and there has to be some judgments, then it will be settled. Yeah. Okay.
Is PF, ESIC, there were multiple things, I've clubbed it all. PF, ESIC, overtime, bonus, variable pay, sales incentives, any of these, can they be made part of the 100% or considered part of 50%? If someone is getting paid a sales incentive, can it be put into the considered as regular wages, and
I
then the
think I'll rephrase the
changes?
question. What they try to understand from a PF inclusions and exclusions
Yes.
is sales incentive, which is a variable pay. Is it included or excluded?
Yeah. So that's what you really, if you look at included portion, what does it say? Any remuneration paid by way of money or capable to be expressed by way of money for fulfilling the terms of employment, whether it is written or otherwise, right? You are given anything that is paid to you is called included wages, and then including basic DA and RA, retaining allowance, is how the first part of the section goes. Now, does incentive or a variable pay fall in this? My immediate reaction to that is that no, because always sales incentive, everything is for performance above what you are required to do, right? Even if you fix a target, you don't pay incentive for somebody achieving 100%. Probably, maybe you will 80 to
I should change the
100%,
policies in my company then.
right? But target is always fixed above a certain what you can normally can achieve, right? From that perspective. So variable pay, all we need to be careful about defining this outside this whole wage concept.
Can we look at there was discussion in the past on fixed component of performance pays, which does not really get impacted mainly because of your performance, and there are variable. So anything which is fixed shall be included, anything which is variable shall be excluded, is one way of looking at it. I may be wrong on that.
Absolutely. That's maybe the only way. So I have a 3-line proposition. One is that, first of all, this variable pay is not for pay working, not for fulfilling terms of acquisition. This beyond that. Second is that you need to de-link the employment contract and incentive policy. Right? Keep it separate. You may mention it. When you say that you will be eligible for incentive, you should make it very clear. When you perform over and above the expectations of these terms, you will be paid a incentive which will be as per the incentive policy. If you word like that, for example, then you already cut that umbilical cord between the the employment and what you are expected to do from the terms of employment to incentive. If you don't do all of that, there is a danger. But even then, the rationale of Supreme Court decision Vivekananda, which goes by component wise, right? Where it clearly says anything that is for additional performance over and above what is required does not fall part of wages, is a so this definition may not really impact that rationale.
Absolutely.
Next question is, can a white collar, when it says worker, can it include white collar employees as well?
We spoke on that. Yeah.
White collar, blue collar doesn't matter. It depends on whether managerial administrative task or not.
Right. If a worker cannot work more than 8 hours under Shops Act, how come 4 days a week, that is 12 hours a day, or 9.5 hours a day can be implemented?
No, no, no. See, people are getting confused with the. This is not the exact work. It is including rest intervals. The length of a working day can be 9.5 hours in some of the shop establishment. What the code and the rule says, it can be 12 hours is what it says. Right? It is not the actual work performed. Actual work performed still will only allowed is 8 hours. Let's say there is rest intervals. See, why 12 hours as a reason? Typically, some of the, let us say, security, right? Sometimes he comes, there is a huge in a factory, there is a lot of work for him when the inflow into a shift. And then after for some time, some of the factories, they even have a rest area, they go and rest, then come back when people, the next shift, the shift ends and the next shift starts. So if you really look at it there, you can define that work to be with a rest interval of 4 hours in between, and then he does 4 plus 4 plus 4. So it is there's a specific term for it. So that is what is 12 hours, not the working hour itself is 12 hours.
I thought they had given reference to 4 working day, 5 working day, 6 working day, and linked it to the number of hours per day. So thought was that if you're not working 6 days a week, if five, then you have to
That
compensate.
is in the Factories Act, some of the states, even Karnataka proposed it, didn't go through, was that for some of the manufacturing, they were wanting to allow 12 hours workday itself. In
Right.
specific, only if approved by the chief inspector of factories in certain kind of manufacturing, and therefore they get 3 weekends rather than 2 weekends, right? And so, but then it had issues at ILO. I keep going to ILO every year. I remember murmurings about it in the ILO secretariat and all that, because that's not as per the ILO convention on working hours. So I think government gave up on it, but we never know. But in what is proposed is including rest intervals, it's not the continuous working hours.
Okay.
How is the responsibility fixed for an organization in case of casual workers who are appointed through agency? Agency is giving us a GST invoice covering all PF, ESIC expenses of contractual workers. So
And stuffing, right? You have taken a
If
employee
if the
via somebody.
contractor, the employer, the war is talking about, he becomes the principal employer.
Correct.
even for casual workers.
Yeah, yeah. If you are doing PF, ESIC, and then there's no, see, there is something called a wage worker, okay, which is the daily wage casual worker. That is separately defined into, that was part of the unorganized Social Security Act. Now that has been defined into it, and then government is thinking of developing some for them as well.
Uh, for FNF or due wages to be paid in 2 days, what happens if the employee absconds without serving a notice period? Is it still required to be paid within 2 days?
No, then then the question of what is this the last date depends on you, no? So you can decide. You have to take a conclusive this thing. You need to have, that's where some of the policies about long absence and how do you treat them and all that is very important. So you have the right to decide which is the last date, and then accordingly you pay it.
Absolutely.
Are direct contractors on fixed payment only with 10% TDS deduction eligible for gratuity, whether retainer or consultant will come under FT?
This is what I tried to address. Today morning also there was this thing. There is a payroll service company. He's saying, "Sir, I do this part of payroll process only, but I give them a separate register for it, right? And they have leaves, they have everything else. Everything is employment, but only the contract is different. Only TDS you direct under 194C, not under 192. That alone may not be enough to distinguish them as not employees, right? So you'll have to be very careful about those contracts."
And those contract terms also does not make much difference when you talk about substance over form.
Correct. Substance over form is an important requirement in law, particularly when in a contract the two parties are not on the equal level. Right? That's why you have labor laws, right? And in that kind of a thing, he will very innocently go after leaving for you and then say, "See, this is a contract I signed, but they told me if I don't sign it, I don't have a job, so I signed up." That's all. If you plead this correctly, any labor officer, every labor tribunal will fall in line with the employee rather than with you. So you need to be very careful about that.
any employee that is classified as a worker can become a member of a trade union or participate in trade union activities?
Yes. So that's where I was saying, no, downstream compliance in IR code is applicable only to workers. So including whether you have to constitute a GRC, which is grievance redressal committee within your organization, and including whether somebody can form a trade union and ask for recognition. Now that recognition of a trade union is made very formal. It's a provision in the law. How do you recognize them, right? All these demands can be made only by a worker or a group of workers.
In terms of definition of a worker, this 18,000 threshold, is that mandatory? Anyone above a 18,000 threshold will only be a worker, even if he is an individual contributor?
No, 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 no. Threshold is only for a supervisor. So it has to be a supervisor and the threshold will come. Supervisor less than the threshold is considered a worker. So you let us say he is an individual contributor, he has no managerial and administrative tasks he is performing, then automatically he is a worker and it doesn't matter what his salary is.
Do you need employee consent to restructure compensation elements?
If you have not built that in your employment letter, please continue to do that. Don't bring in these new theories into all these things. You never needed an employee consent to restructure salary. If you look at any of decently written employment contract, it will always say that employer has every right to change this. Of course, reducing it generally is not accepted. Then you have laws like for the purpose of PF, you cannot reduce wages and all that is there. So there are legal protection also there.
Can you shed some light on the list of registers and returns or list of returns mandatory as per new code?
See, right to the extent government is claiming that we have reduced the returns, for example, in payment of code on wages. Each act had two returns also. You can say look at about 10 returns, right? Now they are saying we will ask for only one return for all the four acts together. So the government is going around saying we will need only four returns. We'll have to wait and see, right? Because we have seen draft rules where states have come up with their own this thing. So we will have to wait. But it will never be the same complicated number. And I believe the government, central government is also working very closely with the states wherever possible to they align fully with the central registers and all of that. So it doesn't really require too many registers to be filed. I
Sandeep,
mean,
you had done a lot of research on this piece, especially for taking Karnataka as an example. While I'm looking at our next question, would you want to throw a light in
I
30
think
seconds?
we had a brief comparison done for the current number of or volume of returns registers that a company have to actually uh, maintain or file in the state of Karnataka versus if the rules gets implemented the way it is mentioned in the draft, what would be the volume? I think based on the initial assessment, what we saw this specifically for a S&D, let's say terms of registers, it is not significantly reducing because S&D still becomes applicable. But for factory, the volume goes down significantly. I think the number of returns that and now a new under new wage a new code, the number of returns will reduce significantly. But so factories gets benefited, but I think establishment I don't foresee a significant reduction of compliances there. But I think I don't want to comment on it unless the rules gets notified. It would be better that we talk about it with specific data points.
Free health checkup is must only for hazardous industries or any organization for people above 40 years?
the central rules are talking about factories and I think plantations and hazardous factories. So we'll have to see exactly how the each state looks at it and then they come up with the rules. But I think they will all stick to hazardous factories and age 40 and above.
Last question I will take. The new laws do not repeal the Shops and Establishment Act. So, how do we ensure compliance under both sides of the act, for both under codes and for shops and establishment? Plus, what about separate registration for SNDPT, LWF? Will this continue or will this get cancelled?
So as rightly mentioned, all the three acts, SND, PT and all that are state acts and they continue. And you will have to continue the registration. Now, what is now new is under the OSH code as establishment, you may be covered, you might have to take a separate registration. Governments are talking about if you already registered in shops registration, that can also be the same. But there is an interesting possibility with this OSH code also providing for leave and leave provisions. So, but then you have to be careful. It is only for workers, but Shops and Commercial Establishment Act applies to employees as well, right? And leave provisions, the biggest struggle for employees spread across multiple states is to how to align leave and then compliant everywhere they are present, which is impossible. Probably now with the central act providing for certain number of leaves, there is a possibility for you to go claim that I am going by central act, and in a concurrent list as per the constitution, the central act has a precedence over the state act, right? But then here the state act precedes the central act. So how will that play out is also a question mark. That is again might get might get decided through some of the disputes. But the question is right. You are having a bit of a complication because so far there not much of overlap between Shops and Commercial Establishment Act and some of the labor law requirements. This thing, but now there is a direct overlap with the OSH code. We will have to wait and see how that plays out. Some states might probably notify notify that OSH codes are over and above for state companies present in multiple states and all that, which is I just heard them in some of the discussions. We'll have to wait and see how this happens.
So at this stage, I think there will be confusions around which policies, I mean, because there's a lot of provisions under SND and OSH might be different. So, and fine.
Sure.
Okay.
With that, I think we've tried and answered a lot of the questions. I think 90% of the questions were anyways addressed during the webinar itself. I would like to thank all the participants across both the Zoom platform and the YouTube platform. We had a peak viewership of about 1400 plus people. So I would like to thank them all for their participation. Please expect the the presentation that was given, the link to this whole recording for you to review again with your colleagues, and the FAQs documented. FAQs will take time to come in because every answer has to be validated by our legal team. But all of that will come to you. We look forward to having you again for the next iteration, which would be on the OSH and the IR codes in a couple of weeks' time. So thank you. Have a great weekend. I would like to thank Sandeep and Madhu sir for their time. We've spent about almost 100 minutes on the call, going through a lot of stuff. Eye-opening for at least me. I'm sure a lot of the attendees would have taken away a lot of detailed information. So thank you once again, and have a great weekend and have a good evening. Bye bye.
Thank you.
Thank you, everyone. Thank you.